Hi, everyone. Harry here to talk about the denial of a shadow docket request from the state of South Carolina growing out of a transgender case. And so therefore, you might scratch your head a little. What's going on? Well, you won't find out, as is normal, from checking out the order list, which just says the application for a stay of injunction pending appeal presented to Chief Justice Roberts is denied. Well, it says a little bit more than that. So first, it goes on to say, the denial of the application is not a ruling on the merits of the legal issues presented in the litigation. Now, it's always the case that a denial of an application is not a ruling on the merits, and yet the court takes pains to actually include that sentence in there, which does sort of jump from the page when you read it. What's going on there? All right. As I read, in between the lines, as it were, has to do with the ongoing battle in the Supreme Court over the four-part test for staying an order below. So you've had the dissents in these cases repeatedly taking the court to task for granting stays that give really short shrift to not just the primary factor of, do we think the people who are seeking a stay are going to win this case? That's the first thing. But that's not supposed to be enough to grant a stay. And so Justice Sotomayor, dissenting from the court's view, and the Justice Kavanaugh concurring opinion on Monday said, look, what about irreparable injury? What about balance of the equities? What about the public interest? In that case, she was saying, what's the big deal about a order from a district court that simply tells the United States, comply with the Fourth Amendment? That really should be no irreparable injury at all. That's a box that you have given short shrift to. So perhaps likewise here, we have the majority, and it's actually a majority of 6 with the three progressives agreeing we're not going to give a stay of injunction pending appeal. And one other sentence, though, justices, you can fill it in probably, Thomas, Alito, and Gorsuch would grant the application. All right, so why are they not? And I think the argument is that this is the state of play of the law here in the Fourth Circuit, where the ruling comes from. And to just leave it in place, I think they are showing they're taking seriously in ways that they not necessarily have done in recent cases, this actual four-part test. So let's rewind a little bit and imagine this is something that has been part of the fights in South Carolina in budget appropriations for a few school years. And there is a person who had been pulled out of school for using the boys' bathroom and was told that they could face expulsion if they continued to do so. But they returned Doe to school, and Doe went to federal court in South Carolina saying state law that says you can't use these bathrooms violates the Constitution's Equal Protection Clause. That engenders a whole kind of series of cases, including one in the U.S. Supreme Court, where the state of play is, let's just say, unclear and unsettled about the state's ability to discriminate against people on the basis of transgender status. Now, the Fourth Circuit, which also is where this case comes from, has another case in which the Court of Appeals just struck down a state law saying that transgender girls can't participate in girls' sports, and held that it discriminated on the basis of sex. That's obviously a pending in the cluster of issues that are now being sifted through and fought over in the federal system. And the court took cert on that case and said it was going to hear it. And in the meantime, the court will do this. It said this case involving Doe, it's really close enough that it's going to be really influenced by what we have to say in the sports case. And therefore, on that basis, the government said, and the district court said, we're going to put Doe's case on hold. And then the Fourth Circuit granted Doe's request to allow the case to continue. So this case is being litigated in the Fourth Circuit, and it was on that basis that South Carolina, not the feds, that could really matter here, but South Carolina comes to the feds and says, emergency, emergency, emergency. We know the script. We've taken it from the many times that the feds have been doing it. Put this on hold, and while you're deciding that other case, don't permit Doe to be at school using the boys' room and the like. And what they said was, yes, maybe the law in the Fourth Circuit points in that direction, but it's an outlier, and pretty soon the Supreme Court, are going to fix that all up. So in the meantime, and especially given the case of Skirmetti, which upheld Tennessee's ban on medical treatment limitations for transgender use. This is the way that the wind is blowing. Understand the wind is blowing that way, and don't let the Doe continue in school while the wind blows. Now, in other cases, it's permitted it to stays to be removed, or it's removed them. And there's a really, this is part and parcel of an overall confusion that the court has engendered. But the two things to say about this case. First, it comes up not from the executive branch, but from the state of South Carolina. And there is federal precedent in the state saying that you can't discriminate against transgender use. That now it's not. It's a case that the precedent may not be strong in a couple years after the court hears this other case, but that's the state of play. And that's the first point. And then the second point is that sentence saying, in light of all of the factors that come into play when we're doing this sort of stay. So suggesting that here, the court as a whole has said, okay, we get it. There's really no irreparable injury to letting Doe continue to use the bathroom until we decide this other case. And then after they decide the other case, they will probably take that case and tell the Fourth Circuit, now that we've decided it, take up Doe's case and decide what should happen based on what we've just told you in this other case about sports, and take it from there. So all in all, does it seem a little bit of a mess in terms of the Supreme Court shadow docket? You bet it does. And it has to do with what's been less than consistent application of the factors that come into play on the four-part test. You know, the court has only under the Trump administration been forced to apply them again and again and again. And you've had strong suggestions from people in dissent in the various cases saying, you know, you've got to do the whole package, and you haven't been doing it here. So here's one in which the court seems to have been moved by that argument, not Gorsuch, Thomas, and Alito. They'd say, nope, we would grant it for now and just say Doe is out of luck, and then remove what the district court has done. And then eventually we'll get to this one too after we do the other transgender youth case. That position doesn't carry the day, and to the extent we have those three conservative justices even more on the kind of right periphery. That little break plays out here. I don't think it augurs anything in general about where the court's going on the other Fourth Amendment case, anything in general about the court's determination of cases involving transgender rights or other social kind of culture war issues. And we ought to think about it just in terms of taking more seriously than they have in other cases the full panoply of factors, 4 factors that you have to satisfy and that the court as a whole thought South Carolina didn't satisfy in order to put the brakes on a district court order. So that's where things stand. It's the Supreme Court not going any higher, and that'll be the state of play in South Carolina. Next thing that'll happen is they'll decide the other Supreme Court case coming up from South Carolina and involving sports. And at that point, they'll tell the Fourth Circuit, think about your case, what you're doing in the Doe case in light of what we've said. That's the way things have always worked in the country generally until this sort of mad cap smorgasbord of action, shadow docket, emergency actions that I've written about recently, and that really the court has green-lighted again and again. It's its own sort of story there. But at least here, there's a little footnote or asterisk to the story saying, but see the Doe case in coming out of South Carolina, where the court did, as it's done in the past, just put things on hold and wait for its normal timeline of deciding full cases on the merits up to a year, and then figuring out the landscape and the lay of the land more broadly in the country. The administration said again and again, don't do that, not here, it's emergency. The Supreme Court has again and again said, okay, we will hear you here and change the status quo. But this time, for I think the 2 reasons I've mentioned, they go in the other direction. Important for Doe, possibly important for where the court's going on transgender rights generally, but not any kind of signal of a whole new approach to the shadow docket, much less assertions of emergency by the executive branch and Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.